Ang susunod na programa ay rated PG. Patnubay at gabay ng magulang ay kailangan sa mga batang manonood.
The views and opinions expressed by the host do not state or reflect those of the company and its management. Furthermore, the views, opinions, and insinuations made by the host, guests, do not reflect those of the show, the management, and the network.
As the impeachment trial of Vice President Sara Duterte moved deeper into its most crucial phases, every testimony, every document, and every ruling could help define the future of Philippine politics. Tonight, we break down the key developments from days 11, 12, and 13 of a trial that may become one of the most consequential chapters in the nation's democratic history. Good evening. I'm Rommel Miranda, and this is the PH Insider on TV. To help us analyze the legal and political implications of today's biggest issues, we are joined by a distinguished lawyer, author, and legal educator. He is the managing partner of the Manalo Valenton Law Offices and the dean of the Pampanga State University School of Law. Please welcome Atty. Jord Jharoah Valenton. Good evening, sir.
Good evening, Rommel. Good evening, everyone.
To complete our panel, we are joined by one of the country's most sought-after political analysts. He is the chairperson of the Department of Political Science at the University of Santo Tomas and a respected voice on national political affairs. Please again welcome our resident political analyst, Professor Dennis Coronacion. Good evening, sir.
Good evening, President Rommel. Good evening, Attorney.
Good evening.
Good evening, everyone.
To give us a detailed breakdown of the Day 11 developments in the impeachment trial of Vice President Sara Duterte, here's Gazi Zarip.
Sa ika-11 araw ng impeachment trial, tumestigo ang COA auditor na si Rommel na walang confidential funds ang mga naging vice-presidente na sina Jord Jharoah B at Leni Robredo, kaya ang OVP lamang ni VP Sara Duterte ang kanyang na-audit. Iniharap din ng prosecution ang 15 kahon ng mga dokumento na may libo-libong acknowledgement receipts habang kinukwestiyon ng ilang umano'y kaduda-dudang entries. Ayon kay Wamil, na-disallow ng COA ang 40 million pesos para sa pagbili ng mga gamot at 10 million pesos para sa mga biyahe dahil hindi ito pinapayagan sa mga panuntunan sa paggamit ng confidential funds. Pinagbigyan din ng Senate Impeachment Court ang BDO Unibank at Security Bank hanggang Agosto at 13 upang magsumite ang mga financial records ni VP Duterte. Muli namang nanawagan si House Prosecutor Terry Ridon na personal na dumalo ang Vice Presidente sa kanyang impeachment trial. Samantala, ayon sa Octa Research, 43% ng mga Pilipino ang nagsabing ang alegasyon ng panunuhol ang pinakamabigat na issue laban kay VP Duterte, habang 28% naman ang tumutukoy sa umano'y maling paggamit ng confidential funds. Ako, si Gazi Zarip para sa The PH Insider on TV.
Let's now begin our discussion with our panel. And before that, Attorney Valenton, Professor Dennis, I just wanted to give some context for our people, to understand the issues that are being tackled in the impeachment court regarding this confidential fund. Number one, the distinction between confidential fund and intelligence fund, because somewhere along the trial, the word intelligence is being mentioned, no? But these are two distinct items.
Mm-hmm.
While they are both special purpose fund, confidential funds are different in the case of the purpose of the confidential fund. These are usually accorded to civilian government agencies, while intelligence funds are for national security, involving national security and law enforcement government offices. So the functions are two very different. And at the same time, one of the things that is important in highlighting here is that the Department of Education or the Vice President office are not legally mandated to have confidential fund, no, but it does not preclude them from having such, especially if they made representation in this particular case to ask for confidential fund to use it in support of their mandate, their own mandate. So based on that, ano po, no, minor premise po, attorney, ano po ba para sa inyo po yung isa po sa highlight po nung testimony ni Rommel?
Okay. Thank you. Well, ang unang-unang, the first thing that we have to consider in relation to the testimony of Rommel is the nature of confidential funds.
Opo.
Confidential funds are confidential, they are classified, the details thereof are not to be compared with regular funds which will be available for the scrutiny of others, of many people, exactly because they are classified. However, in as much as they are public funds, they are subject just the same to audit rules. And the Attorney Rommel testified to the process, the requirements of audit under the joint circular.
Professor?
Yeah, I'd like to ask to Attorney, how significant is Auditor Attorney Roderick Wamil's testimony to the prosecution's case?
The relevance to the prosecution's case is Article 1 of the impeachment complaint, because Article 1 is as regards the confidential funds that allegedly have been misused. So this is very relevant because this is one of the charges and one of the reasons why in the first place we are having this impeachment proceeding.
Attorney, well, some analysts are saying that after hearing the testimony of Attorney Rommel, they said that this is very comprehensive and very detailed, to the point that they're saying that his testimony is enough to nail down the Vice President when it comes to Article 1. Do you believe so?
Well, not absolutely, because we refer to the decision of the Supreme Court, the recent decision of the Supreme Court, in a case filed by Duterte herself, defining what impeachment is. Impeachment remains to be a legal process, although it has political characteristics. So that means it's not fully political. And if we say that it is a legal process, we have the right to due process. And only one has been heard, the auditor. And the defense has to be heard first in order for us to determine whether or not the Vice President should be exonerated or held guilty or be impeached.
Yeah.
Okay, attorney, just for the understanding of our people, does the notice of disallowance mean that the accountable officer, which in this case is the head of the agency, the office of the Vice President, does it immediately give you an idea that there is a criminal liability?
Not yet, because it is just preliminary. Actually, we first have the AOM, and then the notice of notice of, you mentioned of notice of discrepancy, where the other party is given, where the responsible officer is given the information that there are some items or matters that do not comply with the audit rules, and the responsible person is given the opportunity to explain himself or herself. So that means the investigation, the audit is not yet complete up to that time of the issuance of the notice of discrepancy.
Okay, Professor, politically, ano po yung nakikita niyong parang implication na there are several notices of disallowance dun sa Office of the Vice President? Kasi po, some are saying na, oh, this is unusual, this is irregular, but still not necessarily criminal. Ano po yung ano niyo po doon? Idea po ninyo, Rod?
Well, yung pong maraming, tama kayo dyan, President Rommel, maraming mga irregularities that were discovered by former COA auditor for ICFAO na mga irregularities, pointing out na some rules, contained in the joint circular back in 2015 were not followed, were not complied with by the Office of the Vice President as well as the DepEd Secretary at the time when the Vice President was still occupying that seat. So, itong mga irregularities na to, iba-ibang klase yan, attorney, no? Mayroong instead of submitting ORs or yung mga mas matibay sanang dokumento, ay hindi sila nakapag-submit ng gano'n. Ang pinasa nila ay mga acknowledgement receipts. Although this is, I think, acceptable in the auditing process of COA, kaya nga lang, what makes this case unique is that so for the several hundreds of millions of pesos na disbursed, majority of the documents submitted by the Office of the Vice President at saka ng DepEd were mga acknowledgement receipts. Very unusual daw in the process. So this means na ano bang implication nito? Political implication. This creates an impression on the part of the public na mayroong mga magic na ginagawa when it comes to spending and using these confidential funds and intelligence funds. Actually, parang historically, ang pagkakaintindi ng publiko, in common understanding is that parang ito yung hindi masyadong stricto yung pag-audit. Kaya nga prone to abuse by our government officials.
Let me just share some experience po and knowledge on this matter po. Para po maintindihan naman ng mga tao na bagamat sinasabi po na hindi confidential siya, no? It doesn't pass through the usual auditing procedure, but still it is not exempted from audit.
That's right.
No? I think that's what we should emphasize here, no? The reason of the law and the wisdom of this is that all public funds should be accounted. No?
Right.
It should be subject to public scrutiny. Not, of course, in the usual process, in the case of confidential fund or in the intelligence fund for that matter. Let me give a parallel po. In the utilization of the intelligence fund po, in one law enforcement agency po, it's like this, no? The head of the unit would actually call for the subordinate units to pass what they would call as a case operational plan. And the head of this individual subordinate units would actually pass a plan, a case operation plan, wherein they would indicate the situation where it is based, what is actually the mission, who are the agents that will be used, what is the operating unit that will be used. And it is so stringent, actually, that it requires at least 2 meetings in our experience, is that it requires meeting and deliberation from a board. And this is not something like this, no? In my experience, for example, in 2001 and 2002, the amount of intelligence fund that are at our disposal at the time is just 2 million pesos, and that's for the whole country already.
Yeah.
No, and this is the Philippine National Police that we are talking about, no? Na ganun ka-extensive yung requirement for us to conduct intelligence operation, because you have communist movement, you have dissident movement, and criminal groups to operate on, no? So ganun po siya ka-stringent. Now, on the use of alias po, yan. Medyo controversial po kasi sila Mary Grace Piatos, sila Andy Lim. Question, allowed po ba ang paggamit ng alias under the joint circular? The answer po is yes, no? Pero is there a way for the auditor, for example, to actually verify that that person actually exists? There is po. It's just that yung process po is set by the protocol that they devised dito, which is confidential naman po.
Yes.
It is not, unlike other funds na pwede mong tingnan kung sino yung actually tumanggap ng mga pera, dito hindi po. Malilimitahan lang po yun doon sa mga confidential procedure po ng agency. As defined po, as guided by the joint circular. No, Attorney? So, in that respect, yes, they have liberty to dispense, spend these funds based on their intention or objective, but it is not exempted from audit, no? So, I think yun po yung dapat natin ma-emphasize din po sa mga tao, kasi parang sometimes people are already parang they surrender with the fact that that fund is always subjected to corruption or abuse, no? Because confidential. No, it's not. It's confidential because of the use, but the nature of its audit is the same, no? Kailangan pa rin siya. Attorney, let me ask, no? Para lang po maliwanagan din, again, for the benefit of our people po. Yung po bang question, for example po, ni Senator Amy na, teka muna, wala naman kayong COA, wala naman kayong findings na personal na tinanggap o nakinabang ang Vice President dyan based on your investigation. Ano po yung merit ng ganong question po, Attorney?
Well, medyo I feel like it's off.
Opo.
Because the audit is not a trial type proceeding.
Opo.
You do not you do not cross-examine witnesses during audit, and I guess it was mentioned by the auditor during the hearing that it is a facial examination, just based on the documents.
Documents po. The other question that I have is that Senator Amy Marcos is pointing out na, wait a minute, the accountable officer here in this particular case are the SDO, or the Special Disbursing Officer. There's one in the OVP, and there's another one in the DepEd. Now, the position of Attorney Wamil is that the accountable officer here is the head of agency. Do you agree with that, Attorney?
Yes. Actually, all documents, all rules, everything lead to the head of the agency, because in the end, the funds were entrusted to him or her. So he or she is supposed to account and liquidate for all those things.
Hypothetically po, in case the accountable officer fails to restitute the funds, what happens po?
Well, for me, that's a personal liability on his or her part.
Okay po.
So the head of the agency, attorney, is bound to return those funds.
Yes, and he will be responsible. He or she will be responsible for that.
Tsaka may dagdag ko lang, President Rommel, I think if we look into the history of our politics, this line of reasoning by Senator Amy Marcos is often abused by the political bosses. Ganyan na nga. May i-request na funds, tapos naglaho, hindi may paliwanag. Usually, ang scapegoat is the chief of staff. O yung mga subordinates, kung ano man ang position yan, SDO, chief of staff. And in the long run, kapag nagkaroon ng trial, yung mga political bosses, they are set free. Nakapag-bail sila, kasi sasabihin nila, we have no direct participation in this. Tapos, ang kawawa dito, yung mga chief of staff, yung mga, in this case, SDO, kasi sila yung bine-blame
So, ako po, looking at it in my simple mind po, parang in a way, sinasabi ba ni Senator Amy na ang kakasuhan natin yung mga SDO ng DepEd or yung sa OVP?
The rules say that with the failure to liquidate properly, there is a prima facie proof of misuse. So who is in charge of the use of the funds but the head of the office? However, I have to qualify what I'm trying to say, because if we proceed to criminal procedure, which is different from administrative procedure, you have the higher degree of evidence.
Apo.
Not just a presumption.
Apo.
There's a greater constitutional presumption of innocence, which may only be rebutted through proof beyond reasonable doubt.
Yes po.
So when we go to a criminal case, medyo iba na yun. But when we talk of administrative case and requiring the return of the funds, we have the presumption that is against is laid down against the responsible officer of the head of office.
You know, Attorney, Professor, one other thing that is curious about this particular case is that how the money was obtained, no, from the banks. You know, an ordinary person like us, individuals like us, if we, for some luck, let's say we would like to withdraw 500,000 from the bank would require from us a lot of documentation. Or what is the purpose or nature of this withdrawal, and why are you doing such withdrawal? No, and this is not $500,000. This is
Hundreds of millions.
Yes, hundreds of millions, you know. And again, ang pangangatwiran po doon is, well, that might be unusual, irregular, but nothing illegal, no? But again, how do you spend, for example, in the case of the first one, no? 125 million, more than 73 million for that matter is in just 11 days.
11
no?
days.
11 days. How do you do that? Because as looking at it on some of the experiences that we have, as I mentioned, you only have 2 million, and that's for 2 years, and actually the expenditure of that 2 million is for the whole year. And there are accomplishment reports, which leads me to my next question, Attorney. One of the requirements po dito saan po, yung sa audit nila, is yung mga, yung proof how it was utilized. No? Yung po bang AR is enough po?
Well, the joint circular does not, as mentioned, it's not prohibited. It's not prohibited. It's not allowed. Nonetheless, it's still the official receipts and the sale invoices that are more credible proof of expenditure. So you mentioned a while ago of these funds being public funds, and that should be the subject of scrutiny. It should be the subject of an AOM, notice of suspension, and notice of disallowance. That just goes to show that there's a higher threshold that you have to apply. An AR would not usually suffice, especially for this big an amount.
Yes, that's right.
Professor.
President Rommel, let me go back to your previous point about the amount of 125 million pesos being spent in just a
11
short
days.
period of 11 days. And you noted that this is somewhat irregular. Ano? Tama nga naman, 11 days, tapos 125 million pesos. And ang gusto ko rin itanong nga doon, how were these funds withdrawn? Were these released to those offices in cash or through electronic transfer?
Cash.
Just imagine how many boxes of cash were being carried by the staff of the Office of the Vice President and the DepEd. Pero sana, Attorney, kung ito ay na-transfer through electronic means, meron sanang paper trail na malinaw dito, no? Oo.
But, Professor, theoretically and practically, there should be paper trail.
There should be.
Because while I am releasing this to a person with alias, there should the circular mandates that there is a way for the auditor to actually identify the recipient of the fund.
That's right.
Hindi nga lang po open sa public, but there is a procedure, a manner in which the auditor could actually ascertain that an actual person actually received the money.
So I'd like to comment on the last requirement. You said that there should be a purpose
Related to a lawful activity.
Related to a lawful
confidential activity.
Yeah, I remember that the reason cited by the Office of the Vice President and DepEd as well include anti-insurgency campaign.
Oh, wow.
Oo. Tapos anti-illegal activities. Ano pa ba yung mga nilagay doon? Anti-terrorism pa yata. Sabi ko, I was wondering, just like what you said earlier, that you two were wondering, why would a DepEd, whose mandate, Department of Education, whose mandate is to, administer public education in the country, why would it be given confidential and intelligence funds? Because earlier you were discussing the natures of each kind of fund. So talaga bang deserve ng DepEd magkaroon ng ganyan? Klase mga pondo at saka Office of the Vice President?
Okay. From what we know on the core mandate of the Department of Education, it has no legal mandate as far as law enforcement or any national security activities, no? And to talk about this, I think the joint circular would only allow in its support activities with regard to, for example, on this effort, no? For example, if there's really a threat of insurgency in a certain region, and in order to, what I can surmise, Attorney, is that if there is kasi hindi naman po lahat may insurgency problem. Like here in Metro Manila, wala naman po tayong insurgency problem dito. Wala naman po tayo ritong mabigat as na sasabihin nating terrorism problem, no? Because the first agencies that would have to tell us this is not the Department of Education.
That's right.
It should be the Department of National Defense or the Department of Interior and Local Government, because that is their function. So meaning, whatever effort the OVP and the Department of Education has on these matters that they mentioned, it's just actually incidental to their legal mandate, core mandate.
That's true. That's true. Rommel, you mentioned a while ago about the purpose for the use of the funds, and that highlights the fact that, as I said, this remain to be public funds. These are funds of the people. These are not personal funds. These are not discretionary funds. And then we go back to the allocations and disbursements. They should be based on what has been earlier established in the fiscal and financial plan. I believe, and you mentioned a while ago about this plan that you have to come up with. So the disbursements and allocations should be based on this. Now, we have a distinction between confidential funds and intelligence funds. And when we talk of intelligence funds, we talk about national security. And when we talk of national security, the use of intelligence funds, this has to be in collaboration with law enforcement agencies precisely because of the purpose of national security.
Okay. On that note, Day 11 has certainly raised more questions than answers as the prosecution continues to build its case. The next phase of the trial promises even more critical testimonies and legal developments. We'll be right back with more of the PH Insider on TV. Stay with us.
If coffee is your religion, Italy is where your gods live. Here, we honor the barista, not the coffee machine. Because coffee is like life. It's all about how you make it. When your barista is the best, you can taste love in every cup. Our barista is the best. Bravo, Filipino.
I am DJ, I am the Philippines.
The 11 raised critical questions about the handling of confidential funds. But as the trial moved into its 12th day, the testimony deepened. New issues emerged and the legal battle over accountability became even more intense. Let's take a look.
Impeachment trial, ipinagpatuloy ng COA auditor na si Roderick Wamil ang kanyang testimonya ukol sa umano'y irregularidad sa paggamit ng confidential funds ng Office of the Vice President at Department of Education. Ayon kay Private Prosecutor Lorna Kapunan, ang paraan ng paggastos at pagliliquidate ng mga pondo ay posibleng nagpapakita ng isang scam. Binigyang diin din ni Wamil na sa ilalim ng Joint Circular number 2015-01, ang kabiguang mag-liquidate ng pampublikong pondo ay maaaring ituring na prima facie evidence ng personal na paggamit. Naging sentro din ng pagdinig ang pagkwestiyon ng depensa sa naunang pahayag ni Wamil na si VP Duterte ang unang nakatanggap ng confidential funds sa OVP. Nagpakita ang depensa ng dokumentong nagsasaad na may pondo na rin ang OVP noong 2014. Ibinahagi rin ni Wamil na noong September 2023, nakipagpulong ang mga opisyal ng OVP at DepEd sa COA upang magtanong tungkol sa mga requirement sa pagliliquidate ng confidential funds. Ayon pa sa testigo, hiniling din ng mga opisyal ng OVP at DepEd na audit query lamang ang ilabas ng COA sa halip na mas formal na audit observation memorandum at nabigo rin umano ang OVP na magsumite ng mga kinakailangang supporting documents para sa 2023 confidential fund expenses. Samantala, sinabi ng House Prosecution na ang testimonya ni Wamil ay naglipat ng bigat ng pagpapatunay kay VP Duterte ukol sa paggastos at pagliliquidate ng 612.5 million pesos na confidential funds. Iniutos naman ni Presiding Officer Senator Francis Escudero ang paglabas ng bagong sabina para sa isa pang COA auditor na si Celine May del Ocampo na inaasahang tumestigo mula Agosto 5 hanggang 11. Ako, si Gazi Sarip para sa The PH Insider on TV.
Okay, Professor, Attorney, let us now examine these developments, no? Kung ano po yung mga ibig sabihin nila. And I just would like to share this before we start with our discussion. Earlier, we have discussed that the agency must establish the purpose, no, of the expenditure. The requirements are such that it has to be authorized, it has to be necessary, it's actually incurred and relative to the lawful confidential activity. But at the same time, the same joint circular establishes where can you actually use the fund, no? And these are, number one, it can be used for confidential surveillance, purchase of confidential information, payments to informants, undercover investigations, and expenses where disclosure would compromise official operations. At ito naman po yung mga hindi siya pwedeng gamitin. Hindi po siya pwedeng gamitin for salaries and wages, routine office supplies, capital outlay, regular operating expenses, and personal expenses. Now, doon po sa question po actually, meron pong binanggit si Atty. Kapuna, no? Sinabi niya na kung saan ginamit at kung paano ginamit ay it almost amounts to a scam. Paano po kaya, attorney, yung pagbili po ng mga medicine?
I cannot imagine how, at this point in time, how the purchase of medicines would be incidental to a confidential investigation or activity. But what I can say now is that with this development, the burden shifts to the Vice President. Okay. It now the burden is now on her part to explain how such medicines would be relevant to a confidential activity. Because the people might be asking how is it relevant at this point in time, especially with the clear rules under the joint circular.
Professor?
I agree with the attorney, no? Because at first glance, clearly, medicines are not among those items allowed by the joint circular to be purchased or upon which these funds can be used. So dahil hindi siya pasok dun sa exclusive list ng mga items and services na pwedeng pagbayaran ng confidential funds, tataka tayo, alam kaya ito ng Office of the Vice President? Are they aware that such circular exists that serves as a guidance in the spending of these funds?
Oh, interestingly, Attorney Poe actually cited a different circular
which has been repealed.
which has been superseded by this latest Maybe they would try to justify by saying, oh, teka muna, payments to informants may be in form of medicine. Paano po, Attorney?
Mahirap isipin yun, especially the informers any informant would want cash payments. The rewards would often be, would have to be cash. And as you were saying during the break, ang daming gamot nun. Pag ganun kalaking pera.
In fact, doon po sa certification, even for example, kay Mary Grace Piatos po, how much is that amount na indicated, no? Paano po ba nakalagay doon? 70,000 worth of
medicine,
paracetamol or something like that po, no? Parang ganun po. But levity aside, Attorney, Professor, yung pong diversion, for example, diversion, I would consider diversion. When Attorney Poe said, oh, well, by the way, yung claim po ni Attorney Wamil na si Vice President Sara lang po ang may confidential fund, there was confidential fund on the Office of the Vice President in 2014 with Vice President Jord Jharoah B. Ano po ba ang tingin niyo doon?
I feel that's irrelevant because the existence of or the allocation for confidential fund in favor of a former officer is not at issue. What is at issue is how funds have been utilized and how funds have been liquidated in relation to applicable rules and applicable laws.
How about,
that's what's irrelevant.
Okay, Attorney. Yung po sinasabi naman po na issue na, teka muna, nakipag-meeting pala yung, ito po, itong auditor na to sa Office of the Vice President. And he testified that there was a request from the officers of the OVP and DepEd na instead of an AOM, audit query. Is that regular, Attorney?
Well, for me, that is unprocedural. The rules do not. There's nothing in the rules that speak of audit query. And the second thing is the Commission Audit is a constitutional body with a constitutional mandate. I don't think that mandate can be properly complied with or discharged by queries or courtesies that are extended. They have to demand.
Okay.
They have to demand for explanation, they have to demand for documents, they have to demand for compliance.
But Attorney, isn't it an indication of guilt on the part of the officers concerned na kapag kinakausap mo na yung HOA, the optics that is being created is parang umaareglo kasi may kasalanan na nagawa?
Well, I would not be quick to make that kind of a judgment, but I would have to say that rules are rules. If there's an AOM requiring for documents, requiring for explanation, they should have complied with from the very start. And if we talk of the significance of that conference, that speaks of due process.
Okay.
Due process afforded the Vice President.
Yeah.
I think when it comes to regulations, specifically for this joint circular, the wisdom is that these funds come from what we consider as the sacrifices of the people to pay taxes, no? So, I think the strict adherence to the rules and regulations of COA is paramount, no? While there are certain leeway doon po sa sinasabing non-disclosure of the recipients because of the confidential nature of the activity. Yun nga po, sinabi na natin kanina na it's not exempt from audit, no? Kasi, yun nga, they just have to follow the procedure. Okay, now, meron pong magandang statement po na binigay po si Atty. Wamil na sinabi po niya, now, the burden po now shifts to the Office of the Vice President because of what they establish doon po sa kanilang mga findings. In your legal perspective, do you agree with that?
Yes,
Attorney?
the rules specifically provide that the failure to liquidate the failure to explain creates a prima facie evidence of misuse. But of course, in the rules of evidence, there are two kinds of presumptions. Rebuttable presumption and conclusive presumption. This is a presumption, but this is a rebuttable presumption, and it's now for up for the Vice President to rebut that presumption that has been created.
Professor.
Well, ako, I'd like to go back to your previous point. I'd like to relate it to what Attorney Jord has just said. Your President Rommel, kanina you were mentioning about Attorney Powa citing an incident back in 2014, saying that the office of the Vice President back then had been given confidential funds. And I suppose the purpose of Attorney Powa is to debunk the observation of COA auditor that the VP Sara is the only Vice President who has been given confidential and intelligence funds.
But he was talking about his personal experience.
That's right.
Ever since he assumed office.
I tried to look for the amount that was given to VP Jord Jharoah B at that time. And the amount that I saw, based on the initial reports, was that 6 million pesos for that year.
6 million.
It was not even reported whether or not this amount was used by the Vice President. So, just imagine the disparity between the confidential fund given to VP Jord Jharoah B and the current, the one that we're talking about here.
Apo.
So, grabe, in terms of enormity, ang laki ng pagkakaiba.
6 million versus 612 million. That's just 1% of what we're talking about po. No? On another point po, Attorney, ito pong ni impeachment presiding officer, Senator Francis Cordero, he allowed the issuance of subpoena for another COA auditor. What do you think is the possible implication po nitong pag-summon po sa another COA auditor po?
Well, kasi the way the Commission on Audit operates, they operate through a team. So there's an examiner, and then there will be a supervising officer. So I don't want to preempt the testimony of the next COA auditor, but I can speculate on a testimony that seeks to corroborate the process and the findings.
Okay, Attorney, another point. This, based on Attorney Wamil's testimony, there was failure on the part of the OVP and the DepEd to provide supporting documents. That's why there was disallowance po, no? Is there a way for the OVP and the DepEd to somehow cure that at this point?
Well, actually,
by saying, for example, we just recently remembered that there were files there in our offices that we failed to submit. Can they still do that now?
Well, let's talk about the remedial process that is provided under the rules. If you have a notice of disallowance that is not yet final, and that can still be reviewed by the Commission through an appeal. Okay, now I think there's a pending appeal. I don't know which particular.
On the first, it was already it was already dismissed by the Commission itself, and actually upheld the notice of disallowance by the COA.
Okay, if there be if the notice of disallowance has been sustained by the Commission, that becomes final
and executory.
And it can, but there's another remedy, which is a certiorari under Rule 64. But take note of the distinction between certiorari and appeal. A certiorari does not prevent the implementation of the judgment. So, as to the question kung pwede bang hilutin pa yung naging final and executory notice of disallowance, if it has been approved by the Commission, and assuming walang certiorari, that matter is a closed issue.
Would you also agree, Attorney, na after po ng rejection of their appeal, comes restitution, no? But in the meantime, sabi nila, teka muna, i-delay muna natin yung restitution. We're still trying to find out some of these documents or looking for these documents. Is that still possible?
Well, actually, that again my answer is derived from the distinction between appeal and certiorari.
Opo.
A certiorari does not suspend the implementation of the judgment.
Okay.
And the review by the Supreme Court of the finding of the COA is not an appeal but a certiorari. Hence, it does not suspend unless a TRO is issued.
Okay. Professor?
Well, basically, ang nakuha ko doon sa sinabi ni attorney sa kanyang legal perspective, is that it's over. Kumbaga man, there's no chance for the Vice President anymore to look for remedy, for a remedy to this kind of problem.
And tsaka, as I understood what you said, no, attorney, is that you were given a notice of disallowance. So, hindi pa naman po siya final. So, there are some things that you could have done in order to respond to the findings dun sa notice of, or the basis of the notice of disallowance, even before you appeal that po dun sa commission proper. No? So, I think yung pong pag-produce ng document at this point, medyo suspect na po yan para sa akin. No? Yun po yung tingin ko. So, when we return, we'll take a closer look at the major developments from day 13 of the impeachment trial. Stay with us here on the PH Insider on TV.
This is not a cruise ship. Nobody gets pampered. So imagine my surprise.
Chief Officer Jasmine reporting, Captain.
Container ships are tough assignments. You sail with monster cargoes and killer waves. You navigate using lights, depth charts, instruments, and instincts, all at the same time. You always want the best. Then I remembered. She is from the Philippines.
You did a great job, Jasmine. Captain Jasmine.
I am Captain Jasmine. I am the Philippines.
Day 13 marked another major turning point in the impeachment trial. With the Supreme Court clearing a key legal hurdle, the focus returned squarely to the evidence, the testimonies, and the questions surrounding the allegedly misuse of confidential funds. Let's now examine the day's most significant developments.
Sa ika-13 araw ng impeachment trial, ibinasura ng Supreme Court ang mga petisyon ni VP Sara Duterte na kumukwestiyon sa House impeachment proceedings dahil naging moot na ito matapos maisumite sa Senado ang Articles of Impeachment. Sa pagdinig, muling tumistigo ang dating COA auditor na si Jord Jharoah na nagsasabing ang OVP sa ilalim ni Duterte ang kauna-unahang ahensyang tumangging-tumanggap ng isang audit observation memorandum mula sa COA. Inihayag din ni Wamil na sa loob ng mahigit 10 taon ng pag-audit sa mahigit 30 ahensya sa OVP lamang ni Duterte, siya nakakita ng paggamit ng acknowledgement receipts ng walang kalakip na mga opisyal na resibo. Naging issue rin ang posibleng conflict of interest ni defense lawyer Michael Poa matapos malamang dumalo ito sa isang 2023 COA meeting ukol sa pag-audit ng confidential funds ng DepEd. Ibinunyag naman ni Senator Francis Pangilinan na umabot sa 111 disbursements na nagkakahalaga ng 17 million pesos ang inalabas ng OVP sa isang araw lamang, December 23, 2022, na inaming hindi karaniwan ayon kay Wamil. Samantala, inatasan ng impeachment court ang depensa na muling suriin ang 4,492 acknowledgement receipts na isinumite ng OVP at DepEd sa COA. habang sinimulan na rin ang testimonya ng ika-4 na testigo ng prosekusyon na si COA State Auditor Sailin Del Campo na magpapatuloy sa susunod na pagdinig. Ako, si Gazi Sarip para sa The PH Insider on TV.
Let's begin the discussion. Attorney, isa po doon sa naging issue doon is yung pong napakaraming record po ng AR. Sa korte po ba? Sa litigation po? Especially if the document comes from a government office. Ano lang po ba dapat mo i-establish sa korte po? In order for that particular evidence to be admissible po?
Well, relevance.
Okay.
It must be relevant to the issue. Second, it is not excluded by any law or rule, or it's not excluded by the Constitution. That is with respect to admissibility. Yes.
Apo. How about authenticity po?
Well, authenticity is part of the process towards admissibility, because it should be the document as described.
Apo.
So there's the process of authentication.
Imagine po, attorney, for 4,492 ARs, no? Siyempre, kung iisa-isahin po ito doon sa impeachment trial, ano po bang gustong i-prove doon? Can the parties not simply not stipulate on this?
Well, you mentioned of admissibility. The joint circular does not prohibit the use of AR, and it may be considered as admissible. But other than admissibility, there's another thing that courts consider, which is credibility.
Apo.
And between an OR and sales invoice on one hand, and an AR which is easily produced or even manufactured, the AR does not have as much credibility as official documents, such as official receipts.
Opo. That is because you can actually produce an acknowledgement receipt and get somebody to just sign
Anybody
it.
can do that. Anybody can use it. Anybody can prepare it.
In differentiation with an official receipt, which represents some form of legal requirement.
Yes.
Tama po ba, Attorney?
Yes.
Okay. Ikaw po,
Actually, I have,
Professor.
President Rommel, I have a question for attorney.
Yeah, go ahead.
Because it was reported earlier that the petitions seeking to, to nullify what took place in the House of Representatives, in the House Committee on Justice, before the Supreme Court. These petitions were dismissed by the Supreme Court. Does this have a legal impact on the ongoing impeachment trial?
Well, the legal impact is that the Senate trial will proceed without any impediment, without any TRO or preliminary injunction coming from the Supreme Court. There's nothing that prevents the Senate from complying with this mandate of hearing the case. And please take note also that as regards the reason why it was dismissed, it was dismissed not necessarily based on the merits, but based on the fact that it has become moot and academic. You only file a petition to prevent something if it hasn't been done yet. Kasi mapipigilan mo pa eh. In this particular case, when it has become mooted by the transmittal of the articles of impeachment to the Senate. So there was nothing anymore for the Supreme Court to prevent, because the fact has already been accomplished, which is the transmittal of the articles, and jurisdiction has been vested with the Senate.
So it's like the Supreme Court telling the Senate Impeachment Court to proceed with the trial because there's no more legal barrier.
Yes.
So wala nang imminent threat na parang sword of Damocles hanging over the heads of the center judges. So, yeah.
Okay. On the raised issue of conflict of interest of, supposed conflict of interest of Attorney Michael Poa, in his meeting with some COA officials, is this normal or regular?
Well, for me, we have lawyers being disqualified for certain reasons, but I feel that this is irrelevant to the issue as whether or not the Vice President should be impeached. So,
And I think, Attorney, that meeting was in reference to him functioning as
Chief of Staff?
Chief of Staff of the Office of the Vice President at the time. So I don't think there's anything irregular about it because as we know, the Joint Circular allows naman po some type of conferences between the agency and the COA when it comes to discussing matters that are being audited.
yes.
Is that correct?
Yes.
Okay. Thank you po. What do we expect? Professor, let me start with you. What do you expect po in the coming days of the impeachment trial?
Well, as I think as agreed upon by the parties, that the hearings with regard to Article 1 will continue because I think a certain number of days have been allotted for this specific article. So I think that there's going to be more revelation, more disclosures, more information as to how these funds had been spent by the Office of the Vice President and the DepEd. And of course, all pointing out to irregularities that were committed.
Attorney, ikaw?
Well, number one, the audit process enjoys the presumption of regularity. So, and there appears no showing of any irregularity. So the presumption remains. And as mentioned a while ago and as mentioned in the Joint Circular, the failure to liquidate creates a prima facie evidence that there was misuse. So now we have the next auditors confirming that, and we just have to wait for how the defense will address the shift of burden towards their end.
Actually, if you notice the manner of testimony of COA Auditor Wamil, it's commendable. Again, the prosecution managed to show that there are silent workers in government that are very faithful to their job. I'm not saying that there's a negative implication of that on the part of the defense, but the actuation, the manner of speaking of COA Auditor Wamil, and the way he answered the questions specifically of some senators is for me is commendable. I think they have shown the kind of government officials that we should have in these government agencies.
Although there was an attempt to attack his credibility and his expertise by one of our senator judges, sabi ganun, did you have any training, specialized training regarding auditing of this kind of funds? But of course, it was later on, during another senator helped, shed some light regarding, what kind of training is needed.
I think anyone can easily answer that for me, as far as I'm concerned. Any employee in COA who went to office for the first time does not have any experience in COA. You were admitted to COA because you have the necessary knowledge, you have the competence to perform what is required by the office. In this particular case, he exceeds it.
Yeah.
He is an accountant and a lawyer. I think if he is not qualified to be an auditor, nobody can.
He's more than qualified.
Nobody would be qualified. Thank you, gentlemen, for this discussion. As the impeachment trial moves forward, the questions grow more complex, the evidence more critical, and the stakes even higher. In the end, it will not be rhetoric, speculation, or political noise that will matter most, but the facts, the evidence, and the rule of law. The nation continues to watch. I'm Rommel Miranda, and this has been the Page Insider on TV. Have a good night.